We have to talk a little bit about declaratory judgments, which is a very traditional, equitable remedy. So every now and then we've got to look at the more conventional equitable remedies that you should know about. As a general matter, usually declaratory judgments, or requests for declaratory judgments, oftentimes are coupled with other actions that the complaint seeks. Injunctive relief. It might also have other types of legal theories that would support a judgment on the merits as well. Because in some ways, declaratory judgments are seen, and some of the language in the cases today that you saw talks about it's advisory, but it's not. It's more than advisory, but it's oftentimes less than a total resolution to the controversy. It usually means that there likely be at least some other action at some point in time, either some type of compliance issue or some type of further injunctive relief. But if you look at Rule 57, and because it starts with the Rules of Civil Procedure, but really the fact that there is, the rule is very short. The rules themselves, what Rule 57 says in essence is that the rules of civil procedure govern requests for declaratory judgment. And the fact is that there may be another adequate remedy at law doesn't preclude someone requesting a declaratory judgment if it's otherwise appropriate. And also, as is true of most equitable measures, the court will oftentimes order a speedy hearing when a declaratory judgment is sought. And that's simply because of the nature of the relief as to why you're seeking it. Declaratory judgment declares what the rights and obligations of the parties are to a real or threatened controversy. And let's take the last part first, the real or threatened controversy, which is the important thing. It isn't an advisory opinion, first of all. The reason they say there has to be a real or threatened controversy is it's, to some extent, it has to be imminent, that there will be some form of action that will be forthcoming if the declaratory judgment isn't granted. But there's a narrow window where one can ask for a declaratory judgment because it has to, as a general matter, be before suit's been filed, because once suit has been filed, then the argument would be, well, let's resolve it there. And whatever claims both the plaintiff has and the defendant can all be advanced. Sometimes, even by way of counterclaim, the defendant might advance a count for declaratory judgment. But the problem with that is now we've got the controversy and let's resolve it. The declaratory judgment is, in essence, asking the court what the rights and obligations to the various parties to the dispute are. And it has to be further enough along such that legitimately there is a real or threatened controversy. But it can't be so ripe, for instance, that criminal charges have been brought. Well, now you should litigate those criminal charges and defend there. Or if it's civil charges, then we should just simply resolve the breach of contract action or whatever. So when we seek it, there is a relatively narrow time frame where it is appropriate. And what the court will do at that point, and a lot of times it's dealing with potential criminal violations where someone risks arrest. Sometimes it is dealing with land disputes where a party wants to know whether they can enter or whether they can prevent others from entering. Sometimes it may be building issues and the like, and they need that declaration so that they don't spend or waste vast amounts of time on something that's not likely to be fruitful. And what the court does, without the benefit of the jury as a general matter, is issue an order, and the last case in this sequence shows you what that order ultimately looks like. And that case goes a little further than a lot of declaratory judgments, but it allows the parties with some degree of knowledge of their rights and what may flow from that, how they can then shape their conduct so that they would be consistent with what the court has determine the rights and obligations of the parties are. And it's used, as you see, even in this sequence of cases here, in a variety of different ways. In and of itself, personally, I don't see it as that effective of a remedy. As part of a multiple count complaint, it probably would be likely to be sought. But to simply get the declaration without resolving what is clearly likely to be coming almost seems, in my opinion, in part, seems like at times a waste of resources. So I don't use it that often. I've seen it used, but as a general matter, if it's used, you've used it, or I've used it, or others have used it as part of a multiple count complaint, where oftentimes it's not the focus of the complaint. It is a count that you're seeking to grab the court's attention with. I think where we see it used a lot is along the lines of the first case that we're going to talk about, where the DA or the AG is threatening criminal action or threatening some type of enforcement action if someone does something. The person that is being threatened with the action feels they're well within their rights to be able to do precisely what they're doing, and they want to continue to do that, but no one wants to risk being charged criminally and potentially convicted if they can, in fact, get a ruling on that what they're doing is lawful and not have to face all of that. And that's where you see it really useful. It just does, you don't see it that often unless you're really involved in sort of the high-profile criminal litigation, where it's likely, where the one that comes readily to mind, and this was a number of years back now, is where the Institute of Contemporary Art wanted to show some of Mapplethorpe's photographs, and what the Suffolk County District Attorney said is, if you show those photographs in public, we're going to arrest you for pornography. And the Institute of Contemporary Art felt, well, this is art. We shouldn't have to be thinking about getting arrested for this. And so what they sought is a declaratory judgment that, consistent with their rights of free speech and the like, that they would be able to publish these photographs and not risk the curator being arrested on criminal charges. And this type of hand-billing, which obviously goes back a long time ago, but those are the types of things where I think declaratory judgment is most appropriate. Many civil cases, more likely, it's going to be coupled with some other counts in the complaint, the legal theories, the injuries that have been, or not have been suffered, are being suffered in all likelihood. Questions of declaratory judgments? Let's talk a little bit about Steffel versus Thompson, because this actually raises a bunch of different issues, and it's not just issues of declaratory judgment, although that's here. We also have problems, significant problems actually, and this is not uncommon at all, where we have dueling court cases. And the dueling court cases, as a practical matter, happen a fair amount. And they can be from one state to another. They can be between state and federal courts. Oftentimes, what it is one party seeking to gain the higher ground. My rule of thumb, as a general matter, is it's always better to be a plaintiff than a defendant. And I'd always rather be playing on the home court than away. And I'm not the only one that holds those views. And so what happens a lot of times is you have dueling court cases, and the question is, because I'm trying to find the forum where I have the greatest chance of success, and oftentimes the other side is doing the same thing, and sometimes you do get into a rush to the courthouse first, and so then the question is, how do we deal with that? But and that's going to create some conflict among the courts and their authority. So we're going to talk a little bit about that, because this Anti-Injunction Act and the like, and Younger versus Harris, and principles of comity and federalism are important for you to have a good handle on. So first, let's talk a little bit about the case. And this is in fact the case where the plaintiff is seeking declaratory judgment, I think, right? Okay. And what does he want that declaration to say? What is the declaratory judgment he's asking the court's guidance on here?
That he has the right to distribute the handbills in the area that he wants to distribute them in.
That he has the right to distribute the handbills in the location that he's distributing them. Why would that even be a question? Because that would seem to be a matter of free speech, correct?
I believe it was private property.
So you don't have the ability to, you don't have free speech on someone else's private property?
No.
Is that true? Someone, if I go home tonight and sit in my chair, I don't have to listen to someone in the middle of my living room talking about the election or God knows what else, because that's my house?
If they're there rightfully, you don't have to listen to them, but it's more about the trespass on the property.
What's a trespass to property? By the way,
well, the shopping mall is trying to say he doesn't have the authority to hand out the handbills, but they want him arrested, or they're threatening to arrest him for trespass, not for exercising his free speech. At least that was my understanding.
No, you don't have to qualify it. But I want to back up. I want to make a point though here. In this case, the cases we finished with, there's going to be different tort definitions that I know you all know. And I think these are good opportunities to make sure you do know those terms. So what's a trespass?
So entering private property without authority of the owner.
So that's trespass? That's how you define trespass? Entering the private property of another without permission? I'm sorry? Intentionally. Intentionally? So it's intentionally entering on the property of another without permission? You all, is that right? You all agree?
Knowingly and maliciously interfering.
So where are you putting that? Where are you putting that? Where are you putting that piece? Knowingly and intentionally. I just want to know. I'm looking for the definition so that if I were to take notes, that I'd be able to write this and get a decent grade on my bar exam. Oh, you're the ones taking the bar exam. Maybe we better all make sure we got this right. So what's a trespass? Because you said you added knowingly and intentionally. No, you added that.
No, you need to know. Intentionally going on to someone else's property without their consent.
Intentional entry onto the property of the land of another without consent or permission.
Yeah. Yes.
Y'all agree that that's it? I'm not trying to trick you. I'm just trying to. You look like I'm tricking you a
I feel like there's
little.
something missing, but no, I agree with all of that.
But you think there might be more?
I,
Is there more? Because if there's more, then you don't have it yet.
Unauthorized entry onto the property of another.
Unauthorized entry. Well, how come you just changed it from the one you gave me first?
It's the same thing, you know.
Basic tenets.
It's unauthorized entry into the property of another.
That's
Intentional.
Intentional
And unauthorized
and
entry.
you have to have the intent of going onto that property. Only to step. Yeah.
And so it's the intentional entry onto the property of another, either unauthorized or without permission. Okay, you're all on the same page there. So and Fred's right, because that's what they're saying they're going to arrest him for, correct? Trespassing.
But they're not really interested in arresting him, right?
Well,
Isn't
I
that
don't
what the
know
case
that.
is?
Well,
then I've moved.
if he comes back to do what he wants, if he comes back for any reason, or is it just because of
But
what he
there's
wants
no
to do?
real controversy, I think the court finds, because
Wait,
they have no
you're jumping
intentions.
way ahead. I want to break this
Of
way
arresting,
down.
you know?
I want to break this way down to make sure we don't have that many cases to do this week, so we can take our time and make sure we get it right. So he wants. Let me ask you that. So you said they don't care what he does. Is that true?
No.
Because could he come in and shop?
Sure.
He can come in and shop.
They don't want him to distribute the handbills.
So
Who said that?
who said what?
Who said they don't care what he does?
Well, he can shop.
I thought
didn't
you might have said that.
I don't think
Okay,
so.
So they do care what he does when he comes on.
Right.
And what
But
they
they're
don't want him
threatening
doing
him
is
with-
hand billing. I think maybe, didn't you say they didn't want him hand billing?
I said
Right. Well,
Okay.
somebody did. I mean,
Oh, okay.
they don't want him hand billing, but they threaten him with Trespass.
Well,
Oh, okay, wait a minute, though. So
Keep
they,
it from doing.
they don't want him hand billing because they see that as disruptive or for whatever reason. It's their private property and he's not an authorized, is that what it is? He's not an authorized visitor for those purposes?
Yeah, yes.
Yes.
Because then it says if petitioner returned and refused upon request to stop hand billing, a warrant would be sworn out, so just for that purpose.
So they, in fact, as he sees it, they do want to limit his free speech rights. Right? They don't mind if he comes back and shops. Frankly, they don't even appear to mind if he comes back and just sits there. You know how some people just sit in the mall? Some people walk around, just keep walking, right? He can do all of that. But if he starts handing out these leaflets again, they're going to arrest him for trespass. So to some extent, his complaint is tied with his, what he sees as his free speech rights, right? Let's dissect the trespass a little bit. So it's an unauthorized intentional entry onto the land of another. That's where we're at right now. Does that have to be by who? By who? Or does it matter? Like, does it have to be a person?
Yes.
It does?
No, it could be, for example, if you have.
So it's
I don't know,
any unauthorized entry onto the land of
But
another.
there could be like smoke or
So smoke
noise
could be a
or-
trespass,
yeah,
noise,
tree.
tree, light. So it doesn't have to be a person.
Water.
Water, right? Water happens. So right? Are you all in agreement on that?
But the
Could be a bullet shot over some duck pond or some, what was that case?
So they go back to property.
Go ahead.
I am not in agreement because things like water, air, smoke, whatever cannot form an intent. Therefore, those are the things I will classify as a nuisance.
What are you gonna say with
I
that?
think I agree with her.
It's a person.
It's the person.
Think you agree with her?
Yeah, because that's what I was thinking, is that smoke and water, those become like nuisances, and because you have intent as one of your elements, you need to have something that can form an intent.
So definitely intent is part of it. So if I skydive and just happen to land there, because I don't,
Well, it's
tend
not
to,
the intent to trespass, it's the intent to actually go on that property.
but I'm supposed to hit this property where the target is, and I hit this. Is that still a trespass?
Yes.
Well, where's the intent?
Because it's just intent to, like, step, to land there.
Well, supposing there's control coming down and you land on the poor guy's house
It doesn't-
accidentally.
It doesn't
That's
matter
not
that,
trespass,
it's just
that's-
like if you have a boat and it's an emergency, it's
So,
still trespass.
you're all sort of just talking a lot without, you know what I mean, without making sure we're. So, I guess I'm wondering, and I just want a little bit of clarification. So if I jump out of the plane intending to land here, but I land here, but because the wind blows me there, is that a trespass?
Yes. Yeah.
But he says there's no intent to come, I'm saying there's no intent to
It's
come.
not
When you
intent.
jump out of the plane, there's a risk that you'll
Go on somebody
go
else's
on somebody
property.
else. It's like shooting a gun into a crowd of people. You might not intend to shoot some specific person.
Yes.
So if I paint my car outside, and those fumes end up in your yard, even though I didn't intend it, that's the intent, that's enough to satisfy the intent? I'm curious now, because this intent sounds kind of like a nullity. Or is it just some sort of intent to do whatever it is you did? That's the intent?
That's the intent.
So the intent to do whatever you did,
Yes.
period.
Yep, the intent.
So it's not intent to enter, it's the intent to do something.
No. What?
No,
It's
Right?
the intent to step on the property.
But I have no intent to step on this property. The wind blows me here, my target is here.
Right, but you could have, I don't know, you shouldn't.
No, but I remember a case in torts when they were talking about someone leaving a gun, and although they didn't intend for the kid to pick it up, and you have to reasonably, like, assume the possible outcomes, I think, too, in that. So, like, although it wasn't, and it would still be trespass in your scenario, although he didn't intend to land there.
But I don't have a clear understanding of what you guys are telling me that intent is then. Because it's not an intent to trespass.
No.
Okay, say that definitively.
Go where
Give
you're
me
going.
The intent to go where I'm going, which is here.
But no, which is when, as your parachute's going down, you're going down there.
Realize you can't land there,
Yep.
so you land there.
So you're landing.
No, I can't land here because simply the wind blows me. It's-
And you still put your foot down.
And there's no damage.
I don't think you're trespassing.
because I don't have the actual intent to enter?
Right, and as long as you leave, once you've realized that you are not there lawfully, then I think you're not trespassing. I think if you knew that you weren't supposed to go on that land, and you did it regardless, then you were trespassing.
Well, see, because I am sort of wondering all of those situations where, oh no, this is conservation land, the town owns it, but it isn't, and I'm wandering through someone else's backyard. Is that a trespass? Okay, you guys are a little undecided on this, because I'm hearing no's and yeses at the same time. Go ahead.
The intent thing is it is not the same as like an intending to do a crime. It's to get around, like, if you force somebody to go on somebody else's property, the person you force to go on somebody else's property isn't trespassing. So it's the intent that you have. It's like, it could be a proximate cause kind of a thing where you do something that might lead to a trespass. You intended to do it. You intended to kind of set those events in motion.
Do any of you have a law dictionary with you?
I'm looking up,
Is there a
I'm
second
looking
issue?
up online. It says unlawful intrusion that interferes with one's person or property, and it's an intentional tort. But I agree with what he was saying.
Stop. Give us the definition again.
An unlawful intrusion that interferes with one's person or property.
Well, this doesn't sound like the definition you guys gave me at all. No, we agree on that, don't we? Because I didn't hear anything about unreasonable when you guys gave us.
Trespass is an unauthorized entry upon land. And
what's that?
An unauthorized entry
Yeah, but that's,
upon land.
what's that? Fred's Dictionary? Because that's the definition you gave me.
Well, I guess I was right.
The one you read preceding that was completely different. No, right? Wait, Fred, the one you read preceding that had a couple of things that we didn't even talk about.
Call me Mr. Black. Hold on.
Okay.
Mr. Black.
Yes.
Try this one.
What do you have?
Two elements.
What are you reading from?
I'm reading from Professor Martin's.
Oh, Professor Martin. Oh, this is your outline from Professor Martin. Okay. We're going to check with Blacks if it's okay with you, just in case. But no, go ahead. No, read it to us.
Take towards over again. Okay. Two elements: intent and entry on real estate in possession of another. A person is subject to liability to another for trespass when he intentionally enters the land in possession of another or remains on the land without permission, or fails to remove a thing or object from the land which he is under a duty to remove. To have standing, plaintiff must have actual possession or the right to possession, such as an adverse possessor or lessee. Mistake of ownership.
Okay, we don't need the whole thing. Okay. Go ahead.
An unlawful act committed against the person or property of another, and wrongful entry on another's real property. At common law or legal action for injuries resulting from an unlawful act of this kind.
Well, so this whole unlawful act must be a lot more to it than we're talking. Like what makes it an unlawful act then? Because that's sort of, I mean, the definition, that definition seems to have problems with it as well.
There's a little bit further. It says, entering upon land in the possession of another, remaining on the land, placing or projecting any object upon it.
That sounds like Scott's. There you go. Professor Martin and Black are closer. What are you saying?
So maybe, because we have the civil side of trespass where you could be liable for any damage or whatever they can
Right.
prove, but then you have criminal trespass where maybe we're missing an element here which makes it a criminal offense.
Well,
Yes, well, I have a definition that says the act of entering, it's from NOLO dictionary.
Yep.
It says the act of entering someone's property without permission or authority. And then in parentheses it says, although it usually refers to a state, trespass can apply to personal property as well.
Mhm.
Trespassing can be a tort, a civil wrong which the property owner can't sue over, and can be a crime if it's done willfully.
okay, so that's
maybe
part of it too. Go ahead, what?
Maybe it's different intent between the civil and the criminal.
Well, almost
That's
definitely
the-
that's the case. Right.
There's another part to this, as it relates to this case, where it's entry after being asked to leave or re-entering after being told not to get back.
Well, I think you both actually read that, though that part about remaining on the premises, in essence, after you're told you no longer have permission
I
over
think
there.
that's what that case is all about.
It defines a
They use it as a wild
trespasser.
card.
That helps too. It says one who commits a trespass, one who intentionally and without consent or privilege enters another's property. And then it says, to answer your parachuter scenario, an innocent trespasser is one who enters another's land unlawfully, but either inadvertently or believing in a right to do so.
So he's still a trespasser.
It's a trespass,
But he's an innocent trespasser.
but it's
That
probably,
means-
you
Huh?
know, but it's not enforceable probably in total, or it's defendable. It's a defendable trespass, I would guess.
Only if there's damages.
Unless it causes injury, then it's still an unlawful entry.
I think we probably better have a better working definition for the bar.
I'd say stick with the one I gave you in the beginning. No.
Well, it's not a bad definition, but the definitions you just read all have some significant variations from it, right? I mean,
There's gotta be,
Because
an
I'm-
intent-
because
it
I'm not-
sounds like there's gotta be an intent to enter, not an intent to cause injury. Like they would.
oh, I'm sure that's the case. It's not an intent to injure. You could be there and not intend to cause any injury, but
is
still be a trespasser.
The injury is a consequence of the entry, is what it said in here, not
Well-
necessarily.
By operation of law, in essence. You don't have a right to be there and you're there, so there's in essence an injury, even though it may not be tangible. It may not be subject to valuation and the like. Anyway, we can focus on the trespass here as we see it. Does he have permission to be there?
Yes. Because it's open to the public, and that's his case. That's where he makes his.
So does permission to be there mean permission to do whatever it is you want to do there?
No.
Because this is the tension in the case, right? Well, he's saying everyone else can come here, why can't I? Well, the reason you can't is you're doing something we don't want you to do. But he sees what he wants to do is within his free speech rights. If he was out on the sidewalk in front of South Station, train station down in Boston,
It's fine.
fine, right? The problem, the tension here is, well, you're in private property. Like, just like I don't have to look at someone hand-billing in my living room tonight, they have the right to control what happens on their property as well. The problem is it public or private space? And this is where that tension comes in, those of you that had con law and the rest of it, where you must have First Amendment, you must have looked at least a little at this.
A lot.
A lot of this?
In First Amendment.
Oh, in First Amendment, I hope so. Not con law, though?
She didn't, not as much as she would have liked,
Yeah.
because there's just so much.
Well, it's heavily tested on the exam, too.
She tells you that.
Okay.
That's why.
That's how she
that's why it's-
encourages people to do the First Amendment class,
Exactly.
by not teaching too much of it in common law.
Okay.
But it's, enough that you understand what's, what you need to know.
Yeah.
Okay, good. Because I'm actually told this the last essay exam, there were 2 con law questions on the exam, which is unusual, but I think there's reasons for it, but there were 2, one specifically covering First Amendment, and that was February's exam, so obviously you got to be a little bit concerned about it, and should be aware of it as well, obviously, because it raises, as you know, tort issues as well. But at any rate, so what is the problem? He wants to handbill, they don't want him there. What if he goes back and does it anyway? What's going to happen?
He'll be arrested.
Yeah, they're in Georgia, and there's a criminal statute that says after you've received notice, if you re-enter and do it again, you'll be arrested.
And that's probably not just limited to Georgia, but that would be for any of us, right? Is that this basic trespass is and a lot of the stores do this as well for shoplifters and everything else, is that they warn you and they give you a written notice that if you come back, you're going to be a trespasser and you'll be arrested. And you know, even though the public generally is invited, since it is still nonetheless private property, they have the right to deal with their property as they want, and they want to do that here. He, as he sees it, is protected by the First Amendment, and he wants to go back. If he goes back, what's likely to happen, as you would see it?
They'll arrest him.
What evidence does he have that that's likely to happen? Because this gets us into the window of, it can't be just based on conjecture or speculation. You've got to have facts that show this is a, what we call real or threatened controversy. What facts does he have to support that?
There's another case that's going on right now.
Right. His buddy got arrested, right? His buddy got arrested for doing the very same thing. And so this isn't just speculation. He's pretty sure, and he's got some evidence to support it, that if he goes in for to handbill anymore, the next time in, he's going to be going out in bracelets. And now he's going to be charged criminally. He will have to defend himself against that. And the risk, obviously, is subject to incarceration as well, and then has a criminal record. So he's got the real or threatened controversy. And why does he think the state criminal proceeding would be unjustified? What's his argument that he shouldn't be subject to the state criminal proceeding? Go ahead.
Because he is invoking his rights under the under a federal statute, which is the Civil Rights Act, that he feels that, you know, preempts the state statute.
Well, that's what he's invoking here, and let's talk a little bit about that. So what is procedurally, he's worried about the criminal statute in the state, and with good reason. So what's he filed suit?
He files suit in the federal court.
So he files suit in the federal court, and he files requesting, among other things, a declaratory judgment to determine what the rights and obligations of the parties are. You also said he invokes some federal statute, which is what?
Which is the Civil Rights Act of 1871.
Right. He's saying that the
and he wants a declaratory judgment, which and it's he doesn't really. This really doesn't address the First Amendment, whether the First Amendment right, but he just wants a declaratory judgment that the state can't. That what it says is that he doesn't want to get arrested in order for this case to go forward.
Right.
So, and that's what he's saying, that he doesn't have to get arrested, that the Supreme Court can come down and can say that this statute applies, even though I haven't been arrested, nothing's happened to me yet.
Say that last part again, because isn't he specifically arguing that he's engaging in protected speech and therefore?
Yes, but isn't the declaratory judgment isn't this case really about the fact that he hasn't been accused yet?
Well, but see, that's the problem, is he can't be accused. Here's the problem: once he's accused, then he's now past that window where the better argument says you can step in and issue a declaratory judgment, because once the criminal actions are pending, there are other reasons that say you shouldn't involve yourself in pending state court actions. We're going to look at a case that puts a slightly different spin on that. But because of principles of comity and federalism, you should allow the state actions to run their course. That's why he's looking at this, what is a relatively narrow window here, where he's got some ability to ask the federal courts to do something about it. And by him seeking his actions in federal court under 1983, which is the Civil Rights Act, as well as his rights for declaratory judgment. What he's saying is that my civil rights are being denied to me under this threat, and so what he wants is the restraining orders and the like, and he wants the town or the police department to be enjoined from enforcing this state statute. It says here the parties stipulated to the relevant facts. What's that mean?
It means that they basically agreed as to what the facts are. There is no dispute as to what happened or what was said or what was done.
Yeah, it's a little unusual, but really, if you think about what the facts are here, there's no significant disagreement about what they are, and so sometimes you'll do what's called, sometimes you'll stipulate to some facts, but not them all. When we stipulate, we write them up, we sign them, the court has various facts then in front of them, and it makes it easier to get to the merits of the case faster and not waste the court's time. Sometimes, and I think this is one of them, where the case was what we call tried on stipulated facts, which means it's not tried at all. We'll make our arguments, we'll give the court the stipulation of facts that the parties have agreed to and say, okay, here are the facts, you decide how the law then applies to it. And the fact is, in a situation like this, there almost isn't any, there's no reason to call witnesses or compel testimony in any way because everyone agrees to it. And there will be cases like that where it's not summary judgment. The facts are presented to the court, and now the court has to weigh what those facts are and what their meaning, their meaning is, and then at some point then issue the judgment. And again, the facts here are both sides. We agree what the facts are. We simply disagree as to how the law will apply on this circumstance. But it's different from summary judgment. The reason it happens more often in equitable cases is equitable cases you don't have a right to a jury anyway, and so the judge at the end of the day is going to be making findings with respect to witnesses' credibility and what the evidence is as well. So what's this whole thing about? I see Younger versus Harris here. I see the federal court somewhat concerned about whether there has to be bad faith enforcement and the like, because that's what they're talking about here. I look at this very first paragraph where Justice Brennan is looking at it, and he makes reference to Younger and Samuels, and he says that somehow unless bad faith enforcement or other special circumstances are demonstrated, principles of equity, comity, and federalism preclude issuance of a federal injunction restraining enforcement of the criminal statute, and in all but unusual circumstances, a declaratory judgment upon the constitutionality of the statute. What does that mean, principles of equity, comity, and federalism? Because those are important concepts, and what does it mean? I think the case talks about it. I don't know, I'm not really sure it is a good example of what that means. What does it mean when the court says principles of equity, comity, and federalism will generally preclude the issuance of the federal injunction? What's the import of that language?
It means that the federal government can't step into the state's authority to govern. You know, the states have, through the 10th Amendment, the right to police, and the federal government can't just step in. Interesting, we can look at it as applied right now if what's going, the case they just heard.
Right. Right.
I mean, that's an argument there too. They use the Commerce Clause, but the argument is that they didn't have the right to do that.
And there's always this tension. Go ahead.
And that's federalism. Federalism means a separation between the federal government and the state government.
And we tend to, and I've told you this when we first started our studies together, is that we tend to see the federal government as this superior entity, but that's really not what these concepts generally mean. And they mean really that there should be a mutual respect for each other's abilities to regulate and to legislate in various areas, and to try the cases. If it's a matter of state criminal law, then allow the state criminal system to take its due course, and if there's problems at the end of the day, but you shouldn't be rushing in to enjoin these pending state court actions. And the paragraph ends, by the way, with saying, well, if it's been threatened but isn't pending, do you have to show some type of bad faith? And I'm not sure, based on the facts we have, that you would be able to rise to the level of bad faith. It's simply I think what probably is a good faith disagreement among people who are looking out for their own interests, right? He wants to hand build, they want shoppers to be able to shop without having to think about weighty matters and the like, and have a pleasant shopping experience so they can make more money. You know, they both have their own motives, which are personal to each of them. So the court goes through this actual controversy, right? Roman numeral 1, at the threshold we must consider whether the petitioner presents an actual controversy, because that's what Article 3 of the Constitution and the Federal Declaratory Judgment Act requires. Are his alleged threats of prosecution imaginary or speculative, would you say? Do you think his alleged threats of prosecution are imaginary or speculative?
Speculative, if I had to choose. I don't
No, they don't have to be either. I'm sorry. They're putting them together.
No.
Do you think they're imaginary or speculative? Or that if he goes back there, the likelihood is he is, in fact, going to be subject to criminal charges, at least. Penalties we'll see about later down the road.
Yeah, absolutely.
Right? I mean, and I think it is, I think they're right that this isn't just someone blowing smoke, and I think it helps him, not hurts him, that the other has been arrested, because then that's the other argument we'll get back to in a minute, is the fact that the other has been arrested doesn't mean it's overly right either. It shows, I think, a greater likelihood that he in fact will be. It makes reference, the case makes reference to as long as no state court action is pending, because that gets us into Younger versus Harris issues. He is stuck between a rock and a hard place, as the case makes reference to, is that if the federal courts don't intervene, then either he can flout state law or forego what he believes to be protected activity in order to not face arrest. He likely satisfies the real or threatened controversy requirement of the declaratory judgment in Article 3. At the end of the day, does it make sense for the federal court to, let's strike that. Is there anything under these circumstances that bars the federal court's issuance of his declaratory judgment when no state action is yet pending? Is there anything that bars their involvement? No, right? They can. And in fact, it may make sense to, at least under the circumstances as presented here. I thought what was interesting is on page 471, they used the companion case where the guy got arrested to reference Roe versus Wade as well. And while we remember that case in the name, obviously, what we don't remember is Dr. Halford, who was actually Roe versus Wade. They were looking for the declaratory judgment because Halford had already been arrested under the statute for doing precisely what we were looking for the declaratory judgment in Roe versus Wade to issue. But no one remembers Halford's name. They remember Roe and Wade's names. The Federal Court of Appeals in this case thought that they were prohibited from it if he couldn't show bad faith enforcement. At the end of the day, when the court sends it back, has he met the requirements for satisfying the Declaratory Judgment Act? That he's got a real or threatened controversy, that it is an appropriate matter for the federal court to involve itself in, since it does involve matters of civil rights and First Amendment, and even trying to provide due deference and respect to the state court under principles of comity and federalism. There's nothing that precludes the granting of the declaratory judgment if in fact the court determines that it's appropriate. There's some interesting parts of the concurring decisions as well. I just want to ask you quickly about. It says here there's a reference to in Justice White's concurring opinion that says, I would anticipate that a final declaratory judgment entered by a federal court holding particular conduct of the federal plaintiff to be immune on federal constitutional grounds for prosecution under state law should be accorded res judicata effect in any later prosecution of that very conduct. Should be, by the way. So there's not even a guarantee of that. What's res judicata?
The issue has been fully, fairly, and finally
And then what?
adjudicated.
And because it has been what?
And because of what's left.
Claim preclusion, right?
Yeah, but that's a phrase I'm looking for sentences these days. Res judicata is claim preclusion, and collateral estoppel is
Issue preclusion.
Okay, what do they mean? What do they mean?
And it won't be heard. It won't be heard any longer.
Why not? What?
You're barred from bringing that claim or issue to the court's attention again.
Why?
Because it's already been
Done fully, fairly, and
You're
finally
Okay,
adjudicated.
res judicata is claim preclusion, collateral estoppel is issue preclusion, because
And
the
it's
claim
already
or the issues have been fully litigated, fully, fairly, and finally, right, a final judgment. Those matters can't be relitigated either between the same parties or someone in privity with those parties. It's both as a matter of fairness and judicial economy. You get one bite at the apple, and from the standpoint of res judicata, then I'm not quite sure, though, the declaratory judgment is going to be afforded the respect they're expecting in the state court. That'll raise further tensions down the road, obviously. Because I agree with Justice White. It should be accorded res judicata effect, but it may not be. Simply because once the claim has been litigated to a final resolution, and that resolution has been fully vetted and the like, then that should bar any relitigation of those issues. Res judicata is claim preclusion, collateral estoppel is issue preclusion. Anytime there's been a full, fair, and final adjudication of those claims or issues, they are not supposed to be relitigated either between the same parties or people in privity with those parties. The problem is you're going to have different parties on these issues as well, so that would be one of the arguments, but it's only an argument as to why it shouldn't be enforced. If they were in privity with each other, it should still be enforceable and enforced. And then I think some of the other concurring opinions and the like are concerned because they make reference on page 483 footnote 4 that they have to be sensitive to principles of equity, comity, and federalism, because federal courts, as a general matter, should ordinarily refrain from enjoining ongoing state criminal prosecutions. The difference here is there is no ongoing state criminal prosecution, although there is in Mitchum versus Foster. So let's talk a little bit about this one as well. And this one starts us as well into, and so did the trespass, starts us into, well, this week's lesson and next week's with respect to trespass, nuisance, invasions to people's property and their neighborhoods and the like. And they're an oft litigated issue. People spend a lot of money for their homes and spend a lot of time in their homes and their neighborhoods. And over the years, I've had a ton of different pieces of litigation with respect to trespass and nuisance and all of that, the effect it might have on either the neighborhood itself as a whole or even just the individual as well. But so this is the plaintiff, I think, right, operates a pornographic bookstore. And you would like to continue to operate it. This makes reference to a public nuisance. The prosecuting attorney brought a proceeding in Florida court to close down the appellant's bookstore as a public nuisance under the claimed authority of Florida law. What's a nuisance? What's a nuisance? You gotta know what that is too, right? So what's a nuisance?
Something very annoying.
I like this question. But you know, just because you finished the course, you can't put it. You got a definition for us?
No, no.
Oh, well, then why is your hand up?
I was gonna just say roughly.
Roughly. You know, it's funny. Another professor and I had this discussion earlier today about a different subject, which will go unnamed, and the notion that. So I got to have your definition, and no, you don't have to have my definition. You just have to have the law, and right. That is, you got to. Our language has to be precise because you've got to apply it. You're going to define it, and you've got to start to put all of these different pieces together so that you can be comfortable when it comes time for the bar exam. So do we have? So what were you going to tell me about nuisance?
It inhibits the quiet enjoyment
Or something? Is that what you said at the end?
of your property.
Huh?
It inhibits the quiet enjoyment of your property.
That inhibits the quiet enjoyment of your property? What do you got? You got your blacks? You want to go right to the source?
Hey, a condition or activity or situation that interferes with the use or enjoyment of property.
That's pretty
Oh,
Yeah.
Well,
What
it's
you
pretty
said,
good, but I'm
only
thinking
full
it
sentence.
sounds kind of. So like, I've got a neighbor next door that's a pain in the ass. That's a nuisance.
Liability might
If
or
it-
might not arise from the condition or situation.
So well, I didn't hear that. I didn't hear that. Even from blacks, I didn't hear that, and I thought we should have. No.
What's that?
What was your definition again? Well, listen, we could read it for the next 30 minutes, and that wouldn't hurt, okay? From what I'm
A condition, activity, or situation that interferes with the use or enjoyment of property.
See, I'm wondering, and like my buddy Scotty
This
said, I'm
says-
wondering
yeah.
about unreasonable.
It says a private nuisance is a civil wrong is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another's individual property. Without an actual trespass or physical invasion to the land. A public nuisance is a criminal wrong. It is an act or omission
Where
that
you read
obstructs,
from?
damages, or inconveniences the right of the community.
No, what are you reading from? Because I wouldn't make a criminal civil distinction on that basis.
Well, it says a private nuisance is a civil wrong, a public nuisance is a criminal wrong.
No.
No.
How's
No.
that?
It's the
No.
legal definition of nuisance according to Google.
Oh, my mistake.
I had it reasonable to look for.
I mean, if you can't get Wikipedia, Google's the next best site.
It's just 14-year-old girl.
Karen, what do you got over there?
I just have very simply.
Wait, say what?
Simply, a public nuisance is an unreasonable interference with a right common to the general public.
Okay, so unreasonable interference, because even blacks didn't say
That's
that.
what it said. No, well, it has private nuisance, public nuisance, qualified nuisance, temporary nuisance, permanent nuisance.
Yeah, but
I mean,
any nuisance should have
She
said.
just read the Black's definition for private nuisance.
Well, so what were you reading first then? Because you didn't say
There's nuisance, period.
Oh, and
Which is
nuisance
what
didn't
you
say
asked.
unreasonable?
You didn't say what's private nuisance or what's a public nuisance. You said what's the definition of nuisance.
I did. I agree with that. I'm just kind of surprised that blacks would show nuisance as not saying unreasonable, and then put it into private. And isn't public
Well, even
unreasonable as
private
well?
nuisance doesn't say unreasonable. It says a condition that interferes with a person's enjoyment or of property.
What did you read from, Karen, that said unreasonable?
I don't know. It's
You
gone
don't know
now.
what you were reading from?
Yeah, I Googled it.
Apparently
Now,
Google is
public
not.
nuisance is,
Google is not authoritative.
in public, it defines public nuisance as an unreasonable interference with a right common to the general public.
As a general matter, I think,
Such as a condition dangerous to health.
I think your
community
nuisance
moral
definition
standards.
should have unreasonable in it.
Law, LOW.
Well, I can get the phone number.
I doubt that, too. Frankly, I can't get the damn definition. So the only one that you said unreasonable is public.
Yeah.
Okay, and
I
private.
agree with you, though. I mean, it should be unreasonable.
Well, it doesn't. I'm not so sure it has to be either for private.
I think to be actionable, it might have to be. You know, these definitions like trespass, you know, trespass is the unlawful entry onto another's property. Oh, well, I'm not going there.
We're gonna do better than that.
Unlawful,
Okay,
unauthorized.
here's a couple things that we gotta just work through very quickly, right? Partly what we're looking at, one part of the distinction between nuisance and trespass, and we oftentimes see them together, by the way, because there's an argument that A, it could be both, or B, it's one or the other. So as a general matter, when we're actually litigating them, oftentimes we will plead both counts at any rate, and sometimes we will plead both public and private nuisance as well. Because the one I'm going to read you for private nuisance is a non-trespassory invasion of another's interest in the private use and enjoyment of that person's land, right? It's a non-trespassory invasion of another's interest in the private use and enjoyment of the land. But then,
Use unreasonable.
if I had been allowed to finish, what I would say is the question that goes with it, does it create a substantial or unreasonable interference with the use and enjoyment of the property of another? So obviously you can't create a nuisance on your own land. But we are going to look at, especially the cases next week, where we go into fairly significant detail about nuisance, trespass, and public and private nuisance. So, and then what the measure of damages are for those things. So I do want you to think a little more about them, and I think we better come back with definitions that we're all comfortable with. And you should have it because it's not just from the standpoint of it's frequently litigated, but these are pretty basic concepts that we better have a better handle on when you start to apply them for the bar exam as well. But I've had a lot of cases along these lines where you really do need to sit down and try and figure out exactly what that says. So could someone's operation of the bookstore in this case, could that constitute a nuisance to the neighbor's property? Because that's the argument, isn't it? Your dirty bookstore is creating a nuisance to my property because it's an interference with my use and enjoyment of that property. Is that?
Yes.
That could be.
Sure.
Right? You don't want to live next to it.
No, I don't want to, and it's not even so much that, it's the people that it's bringing.
You don't want the people
And the
that are
traffic.
going to go there.
That's right.
So that could be an interference with the use and enjoyment of your own land, even though it occurs on someone else's. Right? It occurs on the one, and this is, they're alleging at least here this was potentially a public nuisance. And I've got here an unreasonable interference, public nuisance with the right common to the public. Interferes with health, safety, peace, comfort, or convenience of the community. Public has to be broader, obviously, than just that private nuisance, but it is that interference that we're looking to establish.
Can I ask a question?
Yep.
So we've all found like 5 different definitions for these things. And is there one, if you're gonna plead a complaint, is there an authority? Like, is Black's the authority, or
Well,
like,
first
can
of all,
you word a definition any way you want based on where you find it,
No.
depending on, right, so what's the authority for these definitions? Professor
Black's,
Martin? No.
well, Professor Martin actually has some pretty good definitions.
That's- yeah,
I've seen his
I think-
definitions for torts,
Right.
and I know he's got some pretty good handouts.
Right.
But he doesn't give them to you during torts, right? He just waits for comparison, I think.
Yeah, he gives
Which
them
I don't
all the
understand
time.
that, but that's what he does.
Right.
And so, here's a couple things. Black's is not a bad place to start. Black's is a collection of the common law. The problem here is, and this is why you see the variations. Trespass is not going to be defined by the federal government. It's going to be defined jurisdiction to jurisdiction. So you're going to see some of the variations that we talked about, and that's the reason why some of the confusion exists. There should be, at the end of the day, a pretty good common law definition that we can hold on to and use. And that's likely to come from blacks, but I'd have to look at what you were reading, because there should be a relatively standard definition that we would all agree. Like, you guys are much closer to trespass, frankly, than we are with nuisance, it sounds to me. But we were missing, it sounded like we were missing some stuff on trespass as well. So I think for Massachusetts, and obviously that would be what you'd be worried about at least first on the bar exam, there has to be a pretty good definition under mass law for trespass, and it's probably likely to have much of what we've talked about. And same thing for nuisance, and that's actually what I'm reading you, at least some of the definitions would be as defined in the mass law, what's a nuisance and what's a trespass. But again, that can differ, and I also, my recollection is, what you guys were saying, what I was asking about, is that the type of intent is not always as clear as it should be. Is it the intent to just, in essence what you told me, when I jump out of the plane, I've got an intent to land somewhere. The fact that I end up landing here instead of there probably is not likely to be a legitimate defense. On the other hand, if Scott throws me out of the plane, I didn't have the intent to land anywhere, and therefore I don't have an intent to do a trespass. And I think my recollection is that you're right on that, so we better be able to define that intent a little better, certainly for the purposes of the bar exam, because you're going to have to make those distinctions then. So, I mean, I think we can do better simply by getting a better definition that we can all agree is more or less accurate. But you do need to know the law that precisely at some point. This was the discussion I had with another professor earlier. It's the precision with which you need to know it, because that's the precision with which they expect you to know it when they test it in the bar exam. When you look at something, they're not going to want a long BS answer of it might not be, or maybe this, maybe that. At some point, at the end of the day, you've got to fish, cut bait, and make the call. And so we've got to get a little more precision with some of that, and that's what I wanted you to start to think about here at least. From the standpoint of the neighbors and from the standpoint of the prosecuting attorney, he feels that there's this issue potentially of a nuisance. You certainly wouldn't want it in your neighborhood. You wouldn't want the people in your neighborhood. What was funny is we had this problem in our town, and what they did, not the problem per se, the whole strip club operation and the rest, and what they said is they thought they'd be real clever, and they zoned an area, because you had to have some area zoned for it, so they zoned an area near the town dump for it. And said, okay, this is the place where you can have strip clubs or whatever, and who wants to be there, and then litigation over many years, because they said, okay, listen, we don't want that, we want a transfer station. And the town said, well, you can't have a transfer station there either. And he said, okay, if I can't have a transfer station, then I'm going to have a strip club. And they said, well, we don't want a strip club in North Andover either. And so, in essence, he's arguing, well, then that's a taking. If I can't use it for the transfer station, which is what I would like, and I can't use it for the strip club, which is really what I don't want, but I know you don't want that either, then someone's got to pay me for the land you took, because now I've got no use for it. And that litigation went on more than a few years with respect to the ability to use that land, because again, no one wants this in the middle of their downtown area, because it does affect property values and it could easily be a nuisance. But people do have a right to run their businesses, and there's got to be somewhere as a general matter in town to do it. And so, I mean, I guess we would all agree, lawfully under the law, he's got a right to run this business somewhere. We just don't want it to be anywhere near our houses, right? Mm-hmm. But as lawyers, we recognize that he has First Amendment rights as well. He then actually decides that since it's a business issue here, that if he's not going to be able to do it here, everyone else is going to complain wherever he tries to go. And he's filed this 1983 action, and as it says in the case, the very purpose of 1983 is the civil rights actions was to interpose the federal courts between the states and the people. This is at Roman numeral 5, 242 of the original decision. To protect the people from unconstitutional action under the color of state law. But the last case we read talked about giving comity and recognition to principles of federalism and the like, that the state has the right to regulate activity within its borders. There was a state court action here. The state court issued an order, preliminary order, prohibiting continued operation of the bookstore. He fought that for a little bit and then filed his actions in the federal courts, saying that his civil rights were being violated. He asked for injunctive and declaratory relief. And he's saying that the law was being unconstitutionally applied to him, and this was causing him irreparable harm. So what happened to all those principles of comity, equity, and federalism? Because we do have pending state court matters, and they're jumping headfirst into it. I thought they were talking about not doing that. To leave the states the right to regulate its activities as well. How come he gets to go to federal court even though there's a pending state court order? And it would seem like this should be a matter best at this point reserved to allowing the state court and that appeals process to run its course. How come this case stands on different ground?
There's always an exception.
So, I'm sorry?
Because there's always an exception.
Yeah, it's probably right. What's the exception?
Irreparable injury.
And 1983 actions, right? I think that's what they're saying in Roman numeral 5. Civil rights actions, 1983 are special. As a general matter, we don't want the federal courts to jump in and be involved in pending state court matters. But if you're saying, and there's a colorable claim, that their civil rights are being violated by the state as a result of these actions, then and only then, at least, do we think you can do it. Now, there's a couple of other exceptions here, and they're Younger versus Harrison, the re-litigation exception, which says that the federal courts also can enjoin pending state court matters if it's to aid their own earlier judgment, so that the matter can't be, in essence, re-litigated in state court. And I think the thing to take away from this, as you start to think about it, is the tension we have between those dual court systems. And that while there's supposed to be a mutual respect for the decisions of the other, and I'm not so sure this case provides that respect, frankly, because he hasn't exhausted his state court remedies yet at the time he jumped ship. He's frustrated by it, but the state appeals process might prove a different result. What the court says is we're carving out exceptions when people bring before us their civil rights violations when those violations are perpetrated by a state or a public actor, is what we should say. I still think it's a tough road to hoe, but this is one example where you might be able to show. Okay? See you Thursday.